Hello, I'm Jessica Ryan Keeney. I am the Department of Child Support Services attorney for two small Northern California counties. And what I'm about to say here today is not legal advice. This is for educational purposes only. If you would, please like the video, subscribe, click the bell so that you get notifications when we upload new content, and feel free to add a question or comment in the comments down below. And if we answer your question, it's still not going to be legal advice, but those make for really good topics for future videos. Thank you for tuning in. Today, we're going to discuss add-backs in child support. What is an add-back? Where does that term come from? I'm going to refer to notes on my computer screen to help keep me on topic, so forgive me for not looking at all of you as I go through this. Hopefully it'll be worth it so that I stay on topic. The purpose of this video is to discuss what add-backs are to income of a self-employed person for child support purposes, and this doesn't necessarily apply to spousal support, but it applies to California only. And again, it's not legal advice. Now, for purposes of this discussion, we're talking about businesses that are organized as sole proprietorships, partnerships, or pass-through corporations, such as some limited liability corporations or S-corps. For purposes of this discussion, the terms tentative profit or loss, net ordinary income, or net income all mean the same thing. And when figuring out the income of a self-employed person, it's common that some of the business expenses are added back to the net profit or loss of that person. But what is the law supporting this practice? Well, in relevant part, Family Code Section 4058 reads as follows. The annual gross income of a parent means income from whatever source derived, except as specified in subdivision C, and includes but is not limited to the following. Income from, income from the proprietorship of a business, such as gross receipts from the business reduced by expenditures required for the operation of the business, and 3, in the discretion of the court, employee benefits or self-employment benefits taking into consideration the benefits to the employee or benefit to the employee, any corresponding reduction in living expenses, and other relevant facts. So basically, this law tells us that when it comes to calculating the income for a self-employed person or income for running a business, the court will calculate the income of that person by taking the gross receipts from the business and subtracting the expenditures required for the operation of the business. When attorneys argue about which expenditures are not required for the operation of the business, they'll often argue that the unnecessary expenditures be added back to the tentative profit or loss from the Schedule C or to the net ordinary income from the business profit and loss statement. And that is where the term add back comes from. For child support purposes, items that are frequently added back to the net income of a self-employed person are depreciation, some or all of the meals and entertainment, utilities, phone and internet expenses, and rental expenses for the home office. And this is all very case specific. And what I'm looking at when I make the argument that these expenses should be added back is, would that person have that expense even if they didn't operate the business? So if the person has a cell phone and they only have one cell phone for business and personal use, and they are deducting their cell phone as a business expense, I'd argue that that entire business expense should be added back because they'd have the cell phone whether they had the business or not. Now, if they had a business line and a personal line, and they're deducting the entire cell phone bill, then I would argue that everything but the business line should be added back. And then as far as utilities goes, if the person has a home office and some of those utilities are for the home office, then I would argue that some of those utilities be added back because they would have those utility expenses whether they had the business or not. Now, if the person has a separate office from their home and their utilities are for that separate office, then I'm not arguing to add those back. And then when it comes to meals, I'm looking at where did those meals and that entertainment happen. So is this something that the person would have done whether they were self-employed or not? Or was this something that they did purely because they operated the business? So I see a lot of meals meal expenses when people work out of town. And I frequently argue, well, they would have had to have eaten whether they were out of town or not. And I see the court look at how reasonable those meal expenses were when that person was out of town. And I see courts sometimes add back those meal expenses and sometimes not add back those meal expenses. This is all very fact specific. The case law I'm going to discuss today deals with depreciation being added back to the income of the self-employed person. And I'm not going to go into a lot of detail on the case law. You can go read the case law yourself. I'll have a link to the case law citations, or not a link, but I'll have the case law citations in the description. I'm probably going to mess up this case name. It's Asfaw v. Woldberhan, and it deals with depreciation of rental properties. And so this is the case that basically the court held that depreciation from a parent's rental properties would be added back to his or her net business income for purposes of child support. And this is, when I'm talking about this today, I'm talking about it for child support only. The court may not add these back for spousal support purposes. That's a different discussion for a different channel. So depreciation on an airplane or business equipment, this was Marriage of Hein, and the court held that depreciation on business equipment, and in this case it was an airplane, would be added back to the net business income for purposes of child support. Depreciation of assets, this was in Remarriage of Rodriguez, and the court held that asset depreciation would be added back to net business income for purposes of child support. And why all of these discussions about depreciation? Because the question was that depreciation really necessary for the operation of the business? And I have people argue to me all the time, well, I need that depreciation to come off of my taxes. Yes, it's necessary for the operation of my business because that's basically a built-in way for me to save to replenish my equipment. So if you have somebody who rents out RVs for a living and they're taking depreciation expenses on their RVs, they're going to have to replace those RVs, and the depreciation is a tax savings and could be a money savings for them to replace those RVs when they no longer work for that business anymore because they get too old. And, it's a viable argument. And in the RV situation, that's actually a good argument because those RVs are only going to last so long. Whereas depreciation on a building, the building, if properly maintained, is probably going to last a lot longer than the lifespan of anyone involved in the case. But anyway, the court has basically said for child support purposes, depreciation is a tax savings. It's not a real expense. It's not money that comes out of the pocket of the parent each month or each year. It's a tax savings. And so the court deems that depreciation is not necessary for the operation of a business for purposes of child support. And the thing to remember is child support, unlike spousal support, is usually not a lifelong endeavor. Usually it terminates when the child turns 18 or graduates from high school. Now there are situations where there may be adult disabled child and child support may continue past the age of 18 and graduation from high school. But again, that's a different topic for a different video for a different day. Now here was one that was a little bit different. This was business income used to reinvest in the business. And this was a Marriage of Blazer, and this was spousal support. So this may or may not apply to child support, but I'm going to mention it anyway. So in Remarriage of Blazer, here in called Blazer, the issue relevant to this discussion is if it was appropriate to exclude the husband's income from the husband's income, money that his business used to diversify the business into other areas to establish a more vertically integrated business. This is a spousal support case, and the court held that it was appropriate to exclude from husband's income money that his business used to diversify the business into other areas to establish a more vertically integrated business. In this case, there was evidence that the business had to be diversified or the business would fail and no longer exist. And so although the holding in this case applied to spousal support, under the right circumstances, it could apply to child support. And I think given the facts of the Blazer case, the court probably would have made the same finding if it had the question of child support before it. Of course, we don't know that because that wasn't the issue before the court. That's just my opinion. So thank you for tuning in today. For the add back discussion, we discussed depreciation mainly. Be sure to like the video, subscribe, ding the bell so you get notifications when we upload additional content. Go ahead, drop us a comment, and thank you again for tuning in. Again, this is not legal advice. This is for educational purposes only. Always consult an attorney about the specific facts of your case, and always be sure to check the case law before you make any argument relying on case law because laws change. Thank you.